Well, we have a lawyer in the studio. Good morning. It's always nice to have you.
Thank you
on the show.
Thank you.
Okay, let's begin with this whole issue with the CCT chairman. The fact that Danladi Umar, who is the CCT chairman, has been charged with fraud by the EFCC, thus cannot be relied on or upon to give fair judgment. That is the case that the suspended CJN is putting forward.
Yes, but I just read this morning in the media that the said charges had been withdrawn by the EFCC. I also read from PR Nigeria that the Attorney General of the Federation had queried both the EFCC and Mr. Kiamo for filing the charges, and that the said charges had been withdrawn quietly before Justice Alilu of the Federal High Court. So it does appear that if that report is correct, there is no pending charges against the CCT chairman.
And but if that is the only issue that the suspended CJN is, holding on to.
I'm not certain if that is the only issue.
So he can still go to
yes, they can still challenge the presiding, whether the chairman of the CCT can still take further action, can still preside over that matter. What the law looks at is not bias. It is likelihood of bias. And I don't want to make any prejudicial comments, but when you look at the antecedents of the chairman of the CCT in relation to this case, what has transpired, specifically the way he has conducted himself, when you have a chairman of a tribunal who sat on the 22nd of January, adjourned a matter to the 28th, on the 22nd declined to take the application filed by the federal government seeking that the CJN should be temporarily removed pending the conclusion of his trial, on the basis that there was a pending challenge, a pending preliminary objection challenging his jurisdiction. When you now have that same CCT chairman the following day on the 23rd, surreptitiously and quietly purporting to have granted an order asking the same CJN to step out, departing from what he had done in open court on the 22nd. As a lawyer, I asked genuinely, can that tribunal be fair? This is not a question that I can answer. It is for the tribunal itself to determine. But I am just saying that the totality of the case, the surrounding circumstances, raises a reasonable issue of likelihood of bias, which has to be resolved. But beyond that, there are also applications, interlocutory applications before the tribunal. Principal among them is the motion challenging the jurisdiction of the tribunal, which has to be determined one way or the other today, hopefully, before any other step can be taken in the matter. So, on the whole, if you look at what has transpired, I'm also concerned about the integrity of that tribunal.
Why?
We have to be careful to insulate the institution of the Code of Conduct Tribunal from the chairman itself. I'm saying this carefully because this is a tribunal that, even in the case of the Senate President, had been shrouded in so much controversy. We have also witnessed a worse controversy in this case. A court of law should not be involved in this kind of controversies. What is the confidence that Nigerians can repose in this tribunal? So we have to also look at this. Can this current tribunal discharge and dispense justice without fear of favor, affection, or ill will?
Okay, now let's move this further. Now, when it comes to the process of removing a CJN, Section 292 spells it out clear. It's so in black and white and so straightforward that there is no ambiguity or vagueness in all of that. But the National Assembly, we're expecting as a third arm of government, even though they have filed, they're filed in the court as the case may be, but what has the National Assembly got to do in trying to resolve this in the spirit of the checks and balances? It
is actually the Senate that has a constitutional role in the appointment and removal of the Chief Justice of Nigeria. That was why when the Senate announced the Senate President made a statement that the Senate was to convene in an emergency session to address this matter. We had anticipated that certain resolutions will be passed, but given the partisan divide, the political leaning, particularly when we are very close to election in the Senate, they could not sit. They have, however, approached the Supreme Court. Whether that case at the Supreme Court can stand in law or not, it is the Supreme Court that will decide. Because I know that under the Supreme Court additional jurisdiction, it is the National Assembly that can approach the Supreme Court and not the Senate. And to even do that, you require resolution. But again, I'm not seized of the facts. I haven't seen the processes they have filed warranting the invocation of the original jurisdiction of the Supreme Court. It is for the Supreme Court to determine whether it has jurisdiction or not. I am also concerned that this case at the Code of Conduct Tribunal is still proceeding, despite the intervention of the National Judicial Council. The Court of Appeal is correct in ruling that there can be no stay of proceedings, because by virtue of Section 306 of the Administration of Criminal Justice Act of 2015, which had been validated in the case of Federal Republic of Nigeria against Olisa Metu, stay of proceedings has been outlawed in Nigeria. So it was even premature and clearly unnecessary for the council, the lawyers representing the CJN, to have sought stay of proceedings. Proceedings cannot be stayed at the CCT. The argument I expect them to canvass today, principally, is that beyond the preliminary objection challenging jurisdiction, the matter has now gone to the National Judicial Council. And law is based on judicial precedent. The same tribunal, headed by the chairman, Honorable Danda Luma, in the case of Federal Republic of Nigeria and Sylvester Nguta, held that it cannot assume jurisdiction when a matter affecting a judicial officer has not been determined by the National Judicial Council.
NJC,
It is not for the citizens to say, no, this case is different from that of Justice Nguta. And as the lawyer will be interested in knowing if there is such a distinction.
But in the meantime, the NJC has given a 7-day ultimatum, which expires, I think, tomorrow or so, for the suspended CJN to explain himself as to these allegations of fraud. And, of course, the acting CJN, Tanko Mohammed, for allowing himself to be sworn in as acting CJN. In the meantime, he is the one who will actually, that's the acting CJN, who will, institute the 7-man bench to hear the Senate suit.
Yes. That is because the Supreme Court does not just consist of the head of that court. You have justices of that court.
This case will go on, and this discussion will keep going on. We have to end it here now because of time. But we thank you very much for coming. We thank you so much.